Yes, there are 6 basic questions that you want to ask yourself. The first question of which is, why should this witness be deposed? Witnesses are only valuable if they have information that tells you something about the facts and circumstances of the event or the contract or whatever was the basis of the lawsuit. So you'll want to ask, why is this witness being deposed? If the person being deposed is not a party to the lawsuit, an independent witness is somebody that probably will turn the case. You can obviously understand why a jury might want to listen to somebody that has no dog in the fight as opposed to somebody that is going to win money or pay money in a particular lawsuit. Sometimes you may want to talk to the independent witness before the deposition is actually taken, but be careful, because you must understand that you do not have the privilege and protection that a lawyer has when you're talking to an independent witness. If that witness is adverse to you, they probably will not cooperate with you. You cannot get access to a police officer or an accountant, for instance, without a subpoena. But if you do know who the witness is because they're identified on a traffic collision report, there's no law that prevents you from contacting that witness to find out what he or she might say. You may want to know additional information that is beyond what is contained on the police report, for instance. And it's important for you to understand that you do not want to have any inference that you have steered that witness to a particular type of testimony. It's okay for you to contact them and give them some advice about how to be a good witness, but you do not have the privilege that goes along with that. So everything you say to that witness could be disclosed to the other side, even if you think that my witness won't say anything that will harm me. One of the reasons you might want to take that witness's deposition testimony is to preserve that testimony for trial. Sometimes witnesses become unavailable because of their age or their infirmity, or they're simply too far away from the courthouse. You cannot simply rely on a written statement. That statement will not be admissible at trial because of the hearsay rules, but a deposition given under oath is always used if that witness is otherwise unavailable. Should I do anything to prepare a witness for a deposition? Maybe. Sometimes you do not want to contact the other witness because there could be some inference of collusion or some way that you're trying to steer the witness or guide their testimony. But I think it's probably okay for you to contact a witness if your information given to them is simply how they can become a better witness, how to feel more comfortable and confident going into their sworn testimony. There are some basic rules that you will want to tell that witness so they can do the best job possible. Remember that you are not a lawyer, and therefore the things that you say to that witness is not protected. You may feel that that witness may not disclose any of those private or privileged conversations, but that is not protected by the law. And the other side may ask the witness if you and she have talked about your testimony, giving an inference that you worked it out or you worked out what was going to be said. The third question you might want to ask yourself is, does this mean I shouldn't talk to the witness at all? Not necessarily. I think it's important sometimes for you to find out what that witness might say, because if the other side is taking that deposition and you know that there is information that the witness has that is favorable to you, you do not want to give up that opportunity to preserve and capture that testimony under oath. Therefore, when you contact the witness, you can ask them casually and candidly if they would be willing to share with you what they know about that particular event that was the basis of the lawsuit. Get the information that is favorable to you and make sure you put that on your outline before the deposition begins. The 3 reasons that you want to take a deposition is to clarify the facts that the witness knows about the facts and circumstances of the event. You want to preserve that testimony in case the witness is unavailable for trial, and you want to assess that witness's credibility. You want to evaluate that witness's credibility. There is no substitute for a face-to-face question and answer period where you can determine for yourself how you think that witness will come across in front of a judge or a jury should the case go to trial. Here's some general information that you can pass along to that witness before the deposition begins. You will want to ask your witness to answer the question that's asked and then stop. You do not need to volunteer information. If you don't understand the question, make sure you tell the questioner that you don't understand. If you don't know the answer to a question, simply say so. If you don't remember the answer to a particular question, simply say so. You don't have to make up things. This is not a test where you are responsible for answering every question. One of the things witnesses are often afraid of is that they've seen things in movies or television where the lawyer sort of beats the witness up and they put words in their mouth. This is proper for dramatic purposes, but rarely done in a deposition. You can advise your witness that they should remain calm and comfortable and not let the other lawyer unfairly put words in their mouth. Yet there are times when a question is entirely proper if they simply state a fact and ask the witness to affirm that fact as true or false. An example would be, your name is Bill Smith, and the answer obviously for the witness is yes. Contrast that with a question such as, what is your name? And the witness is supposed to fill in the blank. There's nothing inherently wrong with one question or another. It's only wrong if your witness allows the other lawyer or other party taking the deposition to unfairly put words in their mouth. Remember, you can advise your witness that it is not their job to volunteer information or to help the lawyer taking the deposition to get information. They have two jobs. The first job is to answer the question that is asked and then stop. And the second job is to be believable and likable. The fourth question you ask yourself is, how do I get myself ready for this deposition? There are several steps to this, and the first of which I think you should do is to look at the answer and the complaint that were filed in this case. I think it's important for you to understand the positions that the parties have taken in front of the judge as the lawsuit began. The second step that you want to take is look at any discovery that was exchanged between the parties. Sometimes written interrogatories or requests for production of documents are given, and so you will want to look at those documents because those documents and answers to written questions are given under oath. The third thing you want to do is you want to look at the documents that you are available. The third thing you want to do is to look at the documents that are available to you, whether or not they were exchanged in discovery. The fourth thing that you want to do is to find out whether there are other witnesses that are out there and find out how those witnesses might differ from what you expect that particular witness that's going to be deposed is going to say. The fifth thing, in my opinion, is you would be well served if you could anticipate what kind of questions you think the other side is going to ask and write down an outline. The outline will give you some information to help you feel comfortable and organized, as well as avoid being flustered during the deposition process. Another question that you might ask yourself is, what kind of attitude should that witness bring to the deposition? You can help him or her by advising her that her attitude should be one of complete honesty. They're going to be taking an oath to tell the truth, the whole truth, and nothing but the truth. As Mark Twain said, if you tell the truth, you don't have to remember anything. By that, he meant that once you tell a lie, you have to remember who you told it to, what the lie was, and how often you have told that lie. You don't want to put yourself in a situation as a witness where the other side has an opportunity to prove a lie and make your testimony unbelievable in front of the judge or the jury.
Is it okay to acknowledge negative feelings about being deposed?
I think you will need to recognize that the witness that is going to be deposed may have some negative feelings about this. After all, they don't have a dog in the fight. They're going to be testifying about something that has no significance to their particular lives. Showing up at another office at a particular time and place is going to be inconvenient, and they may be missing time from work. Some people are just simply afraid to do any public speaking whatsoever. Remind the witness that it might be someday that they need somebody to step forward and be a witness so that justice can be done in their case. And you're simply asking them to do the same in your case. The sixth and final question that you will want to ask yourself so that you can be preparing your witness relates to what kind of questions the witness will be asked. They will be very curious. They may not have done this before. So you can tell them that there are several basic stages of the deposition. First, they're likely to be given some instructions and guidelines and be reminded how important the deposition is. Second, they're likely to be asked some questions about their education and employment background. Third, they are absolutely going to be asked questions about what they know concerning the facts and circumstances of the event. Those questions will probably be areas of our senses. What did you see? What did you hear? What did you touch? What did you taste? What did you sense about what was going on at the scene, or concerning the signing of the documents, or that sort of thing? So, if you can help them understand and ask them what did they see or hear or taste or touch, they will be better prepared to answer those questions at the deposition.
And then other witnesses, other documents, and then what opinions do they have?
Yes. The last portion of the deposition is likely to be asking this witness whether they are aware of any other documents that relate to the event and whether or not they created like a diary or some kind of reminder that could help them refresh their recollection about the events. They may be asked questions about whether they know of any other witnesses. Say a breach of contract case, there may be a lot of people in the room when that contract was signed, and so they may be asked to identify several other witnesses if they know of any. And finally, they may be asked some opinions about the witnesses. The questions about whether they're credible, whether they're believable, whether they're likable, whether they saw anything about the other people at the scene that might undermine their credibility. Those are the kind of questions that the witness may be asked.
How long, to close this one out, how long might it take to have a deposition?
Some people want to know how long they're going to be involved in the deposition. We know from experience that many depositions last approximately 45 minutes to an hour in a simple civil litigation case. Sometimes it could last up to 2 hours depending on the complexity of the case. I guess you could remind the witness, if they stay on point and answer the questions directly and don't spend a lot of time volunteering information, the sooner they're done, the better they'll feel. You will probably want to remind the witness that being direct and to the point will make the deposition shorter. And the sooner they get done, they're out of the spotlight, and that's a good thing.
And then a closing. Obviously there's more. I hope this helped. Good luck.
Okay. Obviously, there's a lot more we could talk about regarding this topic of depositions, but we've run out of time. I hope that I've given you some guidelines and pointers that will help you prepare yourself, feel more comfortable and confident going into the deposition process. I obviously wish you nothing but all the success in all your endeavors.